advice.
Good morning, everybody.
Vastola on the Law with your host, attorney Jeff Vastola, featuring 30 minutes of free legal advice. Call in now with your questions. 877-850-8585. That's 877-850-8585. Now here's your host, attorney Jeff Vastola.
Good morning, everybody, and thank you so much for tuning in for yet another edition of Vastola on the Law. I am Jeff Vastola. I am an attorney, and I am here every Saturday morning to give you free legal advice. All you have to do is sit back and listen, or better yet, to make the show more interesting, please call into the program or type in a question if you're watching by Facebook Live, and I will do my best to answer your question right here and right now. If I cannot, if I have to do some research, then that's exactly what I'll do, and I will get back to you the following week with what I consider to be an educated response to the question. And of course, you can always follow up with more questions after that. As I mentioned to a caller last week, somebody, I used to do the show on a different station many, many years ago, and there was a gentleman that called in one week, and he had a small claims issue, and it was pretty interesting because it turned into a saga, where every week the guy would call in, maybe not every week because cases are not always that active, but we walked him through his entire case, through the life of his small claims case from beginning to end. Good morning, Merrill. And I believe that he appreciated it because every bit of advice that I gave him was free. And that's the way it works here on the show on Saturday mornings. It's free legal advice. If you would like to be a part of the program, you can do it two ways. You can type in to Facebook Live, and if you'd like to be a viewer of Facebook Live, then just friend request me if you haven't already. And around 7:30 on a Saturday morning, if you are on Facebook, then you should see some kind of a pop-up window that says Jeff Vastola is live, and you just have to click that, and off you go, and you can watch by Facebook Live, and you can type in comments such as my wife just did. Good morning, my beautiful wife, Mandy. And if you prefer just to listen on the radio, you can do that too. 850 AM is the station. And if you'd like to call into the radio station, which is what I like, that's what I prefer, then dial 877-850-8585. I want people to call into the show or type in a question. If I can get to it, I certainly will. But the verbal interaction really makes the show much more interesting. So if you're just sitting back thinking, well, I've got a question, but I'm going to let somebody else do it, or I've got a question, but I'm just going to listen to Jeff talk today, I would prefer that you call in. And for those of you that call me during the week, for those of you that have left me voicemail messages during the week, I have returned phone calls, and I have said in response to your messages in a message of my own, please call me on Saturday because your question is ideal for other people listening because they might get something out of it. Not only you, but other people. So the number to call into the show, 877-850-8585. Please call me immediately. Don't wait for me to stop talking. Now, a little bit of self-promotion because I oftentimes don't do enough of this. I, during the week, am a personal injury lawyer. I handle injury, wrongful death, and medical malpractice claims. I have 2 brick and mortar office locations, one of them in Palm Beach Gardens and one up in Stewart, Treasure Coast. So if you think you have a case, if you want to discuss something with me, then call either office. You can find out all of our location information, our contact information by going to our website, which is www.vastolalegal.com. My last name is spelled V as in Victor, A-S-T-O-L-A. Vastolalegal.com is the website. And if you'd like to reach me directly, 24/7, weekend, midnight, I may not answer at midnight, but you can give it a shot. My toll-free number is forwarded to my cell phone, and the toll-free number is 833-VASTOLA, which is 833-827-8652. So give me a call. Let me know if you think you have a case that you'd like to hire me for, and I'll be happy to give you at least a free consultation, which is not unusual in my industry. You see that all the time. But yeah, absolutely a free consultation. And more importantly, if I'm not going to take the case for whatever reason I decide I'm not going to take the case, I'll share that with you so that you understand why. I know that in having more consultations than I can count, and oftentimes being a second opinion. What frustrates people more than anything is being told, we're not going to take your case, but then not being told exactly why. So they're left kind of wondering, well, what is it about my case that nobody wants it? I am always willing to give you my opinions. Of course, I'm very likely going to cover my derriere by saying I would recommend that, of course, you speak with somebody else, but at least I'll give you my opinions as to why perhaps I don't think you have a case. Or if you have a case, because understand, in the legal world, having a case or not is not usually black or white, yes or no, like the flip of a light switch, it's on, it's off. A case is typically somewhere on a spectrum of being absolutely positively no case to absolutely positively the best case on the planet, and most cases fall somewhere on that spectrum. Some cases fall very close to the other end of the spectrum that says, no, you don't have a case, and that's when typically I'll explain to people why. Good morning, John. Nice to see you, and it was fun to have you on the boat yesterday. Appreciate hanging out with you and the boys. So if you'd like to call me on the show, 877-850-8585. That's the number to call in and be a part of the show. Call me with any question you want. Last week we had a woman call in with a landlord-tenant issue, and hopefully we gave her some good direction, and we might hear from her again in the future just because of what's going on in her world. But that's why I'm here. If you have something going on in your world and you'd like some free legal advice, or sometimes maybe just some direction with a legal issue that you have, then that's why I'm here. Now, of course, because Saturday mornings do tend to be a little quiet, and I don't always get phone calls, I have my outline prepared. And today I'm going to do one of the things that I really enjoy doing. I'm going to read some cases from my Florida Law Weekly. This may not be entertaining to everybody, but I find it interesting because when I read through these cases, these are cases that are in every area of the law. It's not just what I do. There's oftentimes criminal cases in here, family law cases in here, but every once in a while there's cases in here that are exactly what I do, which I find incredibly interesting, or they're similar to what I do and either procedurally or taking from the common law where there's some discussion we can have about it. I see that my Aunt Vicky is watching by Facebook Live, so good morning to you. I'm getting some back and forth about whether I should say hello to people that are, chiming in on Facebook Live. And my personal preference is I like to say hi. I like people to know that I see them there, and I appreciate you taking the time to sit with me on a Saturday morning, especially my family from so far away that a lot of you I haven't seen in way too long. But some people say that it's distracting from the actual content of the show. So for those people that are irritated by it, I certainly apologize. But while I'm waiting for somebody to call into the show, I'm going to be talking about some of these cases because I can extrapolate from the facts and the circumstances of this case and apply it to what I see or what I've seen in my own practice, and it's usually pretty interesting. Now this is a case I'm going to talk about. I'm just going to jump into this stuff right away. I am waiting for somebody to call me.
Well, Jeff, I'm sorry to interrupt, but we have John from Jupiter.
All right. Well, that was perfect timing, BJ. I appreciate that. We've got a guest board operator. Okay, so
John, can you please turn your radio down?
Yep. All right. So let's get through this. John in Jupiter, you're going to have to turn down your radio, my friend.
Okay, I'm going to place him on hold. I'll let him know to turn his radio down.
Okay, no problem. Just let me know when he's back on.
Okay.
Yeah, so somebody, that was perfect timing. Good morning, Uncle Jeff. Nice to see you. Had reached out to me with a voicemail message saying, this is my issue. And it was kind of a lengthy message that he left. I called him back and said, this is precisely the kind of thing that I'd like to hear about on the radio because it might help other people. So that individual, I am waiting for him to call. I don't know if that's our individual from Jupiter, but hopefully it is.
All right, Jeff, we have John back.
All right, let's talk to John from Jupiter. Good morning, John. John, you're up. Hello, John. We've got dead air. Hey, VJ, can you figure that out?
Yeah, let me, I'll place him back on.
Yeah, all right.
Sorry.
No problem. Thank you. All right, so this case that I'm going to talk about first while we get John on the phone is Carla Bay versus USAA, which is United Services Automobile Association. That's an automobile insurance company. This is out of the 4th DCA, so this is in our own backyard, so to speak. Now, of course, this is, I shouldn't say of course, but this is Broward County, which is still 4th DCA. Broward County, for those of you that don't know, is the greater Fort Lauderdale area. It's south of here, but it's still in the 4th DCA, which is what they call controlling or mandatory authority when we are looking at cases. Anything out of the other 5 DCAs are not controlling authority in the 4th. They might be persuasive, but they're not mandatorily part of the 4th DCA unless the 4th DCA adopts it. So this is a case out of the 4th DCA. And the reason I wanted to mention this case is because there was a case several weeks ago that I talked about where another attorney down in Broward County, 4th DCA case out of Broward County, where an attorney had filed what's called a civil remedy notice, which is something that needs to be filed against an insurance company in what's called a first party action in order to get a claim or pursue a claim of bad faith against the insurance company. So if anybody wants to know more about that stuff, then let me know, but that's tangential.
All right,
So,
Jeff, we have John back. I'm sorry to interrupt.
That's okay. All right.
Here he is.
Thank you very much. Good morning, John. What can we do for you, son?
Yeah, I just have kind of a weird question. Are you still there?
Yes, I am. You're up.
Okay. If I'm involved in a personal injury case, and someone says I'm at fault, and they even hire you to prosecute me, what type of lawyer helps me out, or where do I find a lawyer? Is it, it's a home case, is it homeowners insurance, or an auto case, is it my auto insurance? But
Yes.
the question is, who do you usually find as defending your clients?
Well, it's typically the insurance company, and is your name John or Don?
John.
John, yeah, John. Excellent question, and thank you so much for calling in. The answer is, if it happens at your home, and if you have homeowners insurance, the homeowners insurance company will oftentimes defend. If it happens in your car, your automobile insurance company will oftentimes defend you. If it happens at your business, and if you have a general liability policy, well then the general liability insurance company will oftentimes defend. And if you're wondering why, it's because when you buy insurance, you are executing a contract. And in that contract, it says that you agreed to pay the insurance company money, which is the premium, and then in exchange for the premium, the insurance company agrees to do a lot of different things in exchange. One of those things is that if you get sued, the insurance company will hire an attorney to defend you. And then, of course, pay, if the jury says they have to pay, whatever amount up to the policy limits they have to pay. Those policy limits are something that you've contracted for, so that's stated in the contract how much the insurance company might be responsible for on your behalf. But John, that's the answer to the question. And so if you have any follow-up to that, I'd love to talk with you about it, but it gives me an excellent segue into something else that I wanted to talk about. Do you have any other questions?
No, and I'm not in trouble. I listen to your program every week, so I was just curious who you go against.
Yeah, so I really appreciate that call, John, because it's given me something to talk about that I've never really thought of before. But and John, we can hang up, but thanks for calling in. For those of you listening, if you ever get served with a lawsuit, and if it has anything to do with negligence, make sure that you give that lawsuit to your insurance company right away. Because, first of all, you don't want to pay for legal services if you don't have to, because the insurance company is probably obligated to at least hire an attorney to find out if there's a basis for defending. Secondly, if you delay, and if the plaintiff's lawyer gets a default judgment against you, then it could be difficult or possibly impossible to set aside that default. And a default is an automatic win for the plaintiff. And if your case could be defended, you don't want the plaintiff to have an automatic win. So there's two different anecdotes that I want to give in response to John's question today. And so I'm going to set aside my case law, my Florida Law Weekly, and talk about these two things. The first one is the importance of having appropriate coverage on your homeowner's policy if you have dogs or animals that may cause injury to somebody else. And even if your dog is only 5 pounds, if you know that your dog is an aggressive dog that tends to bite people or chase after people, if your little 5-pound dog is mean and chases after a little 5-year-old kid on a bike and causes that 5-year-old kid to wipe out and break her arm, guess what? You're responsible because it was your dog that caused it. So when it comes to animals and homeowners insurance policies, make sure you ask your agent if you are covered for your animals. Because what happens is most people are not aware that there are exclusions in just about every single homeowner's policy for animals. So if you don't agree to pay a little bit more money to cover your animals, then you will be personally responsible for any damage that they cause. And understand that animals can cause either directly because of a big dog bite that can become infected and limbs can become amputated. I mean, if you think it through, animal claims can become very, very significant claims. Or secondarily, the example I just gave you of your dog chasing a child on a bike and the child wipes out. The dog may never have come into contact with the child, but secondarily, the dog caused it. And so you don't want to be responsible for those things. And if you don't ask, you may not know that your animal's not covered. And what's important is to understand that it's not that expensive to cover your animals. What you need is what's called a rider to your insurance policy, sometimes referred to as an endorsement. And if you pay a little bit more money in premium, the insurance companies will oftentimes add that endorsement to your insurance policy so that now you're covered. And so, up to the agreed upon insurance benefit, homeowners policies are $300,000, $500,000, sometimes $1 million. I have a case right now where the homeowners insurance policy is $1 million on the premises, and then the homeowner actually has an umbrella of another $5 million above that. So there's a claim value of up to $6 million where this defendant is covered. So the takeaway from John's question with regard to homeowners claims is make sure you're covered, because if you don't ask, you may not know. And that's one of the reasons why I do the show, because I want people to understand, I want people to know what they don't know about insurance specifically. And of course, if you've watched my show, insurance is a hot topic for me, especially automobile insurance in Florida. Again, I'm only licensed in Florida, so I'm not talking to everybody up there in New York and the North Carolina, South Carolinas, people where my family are located. But in Florida, automobile insurance is kind of iffy. And a lot of drivers that are otherwise fully covered on the road are not carrying the kind of insurance that can protect you. So you have to make sure that you have the right kind of coverage on your policy. So today's topic is not automobile insurance. It will be again soon, I promise. But if you have any questions at all about automobile insurance, call me. That 833-VASTOLA number is an ideal number to call me to ask me questions about your insurance policy, because I'm very happy to talk about that. But the second takeaway from John's question has to do with automobile insurance. And I kind of alluded to it a moment ago. Making sure that you give the policy to your insurance company, the lawsuit, to the insurance company right away if you get sued. Car accidents are one of the more common types of injury lawsuits that are filed. And sometimes, I see it all the time, when the defendant gets served, our process server will go serve the defendant. The defendant doesn't give the lawsuit to the insurance company because they don't realize that the insurance company is going to pay for the defense. If you're an individual, when you get served with a lawsuit because of a car accident that you caused, assuming that you had insurance in place on the date of the accident, understand that the insurance company is obligated to pay for your defense attorney. Now, you might get a letter from the attorney that's ultimately hired saying, unfortunately, we feel as though the potential liability may exceed what you have in coverage with this policy, so we strongly recommend that you go out and get an attorney of your own. Reading between the lines, it's not really reading between the lines. It's the insurance company's obligation to inform you, to warn you that you might be liable for what's called an excess judgment, where the insurance company, let's say for example, you only took out a minimum amount of bodily injury coverage of $10,000, but you caused an accident and you catastrophically injured somebody. That $10,000 of bodily injury coverage is going to be woefully inadequate to cover the claim. And so what the insurance company is doing through its lawyer that it hired to defend you is they're saying, uh-oh, we've got a situation here where your potential liability exceeds what we have to pay on the claim, because contractually they're only obligated to pay $10,000. Now, interestingly enough, in a catastrophic injury type of situation, if your insurance company has not tendered that $10,000 soon enough, then the insurance company could potentially be on the hook for the entire amount of whatever the verdict or judgment may be through a claim of what's called bad faith. So, and I want to, those claims are very, very few and far between, but when they do happen, they are meant to protect, believe it or not, the defendant. And the reason why is because when the insurance company acts in what's called bad faith, then the defendant is not meant to be punished by that. So anyway, John, great phone call. I appreciate that. If anybody else has any phone calls, even if it's just something as innocuous as, what do I do if somebody serves me, then obviously it stimulates me with a lot of stuff to talk about, as you've just seen. So call in with whatever you want to call in about. And I might even make one of those issues my topic for next week. And that's oftentimes what happens. But I got about 5 minutes left, so I want to get back to this case I was talking about. This case is Carla Bay versus USAA out of Broward County. It's a bad faith case. And I mentioned several weeks ago, I talked about another bad faith case where an attorney down in Broward County had filed a civil remedy notice. Now that was for a property damage claim. This case of Carla Bay has to do with automobile coverage, but it's similar in the holding in that we're dealing with a civil remedy notice. The holding is actually contrary to the other one, but that's why I want to talk about it. The topic is the same. The topic is a civil remedy notice that was filed by both lawyers. The lawyer down in Broward County that filed one for the homeowner property claim basically recited the entire insurance policy language in the civil remedy notice, but did not follow the statutory template that is contained in the civil remedy notice online filing. If you're going to be filing a civil remedy notice, if you're not a lawyer and if you have a lawyer and you're involved in a case like this and you need to file a civil remedy notice, make sure you ask your lawyer, did you follow the template? Because if you follow the template, you're not going to have a problem. Well, even though the lawyer in the earlier case had cited almost every section of the entire insurance policy, the 4th DCA reluctantly had to hold that his civil remedy notice was deficient. And because his civil remedy notice was deficient, his bad faith claim against the insurance company got thrown out. Now this case holds that although the insurance company tried to make allegations that the civil remedy notice was deficient, because once again you have a lawyer here that didn't follow the template that's set forth in the online filings, USAA waived its right to defend on the deficiency because it never pointed out the deficiencies of the civil remedy notice in the process of responding to it and ultimately in the filing subsequent. So
2 minutes.
That is an issue that can be waived by the insurance company if it's not properly preserved. So if you're an insurance defense lawyer and you're watching my show, I doubt there are very many of them, but if you are, and if you have civil remedy notice cases and you feel as though one's been filed but is deficient, make sure to put the plaintiff on notice. You have to give the plaintiff an opportunity to cure. And if you don't, then you may, on behalf of your client, you may have waived this defense. And that was the ruling in this case of Carla Bay versus USAA, where the civil remedy notice was deficient, but insurance company waived the defense. So if you're going to file a civil remedy notice, just follow the template. It's online, and all you have to do is kind of fill in the blanks. But if anybody would like to talk to me in private, if you have an issue going on that you just feel is too personal to share with everybody else, then call me at 833-VASTOLA, and I will be happy to talk to you. Thank you, VJ, for your services today as my fill-in. And thank you, John, for calling into the show. I'm going to wrap up with this. For those of you that don't already know, my father is still in the ICU fighting for his life. This has been an unbelievable roller coaster, and we really, really appreciate all of the prayers that you have already sent. But we ask that you continue to pray for my dad, because he really, really needs it. He's in bad shape, and we love him, and we just want him to come home. So thank you, everyone. I hope everyone had a fantastic Thanksgiving, and we'll see you next week. Thanks again, VJ. Take care.